the Executive Committee of the Southern Baptist Convention, and Ms. Christy Peters.
Okay.
Mr. Matthew Peach represents the Southern Baptist Convention.
All right. Will there be more than one argument if y'all divided the time?
Your Honor, we've divided time. I will make the principal argument 10 minutes and reserve 5 minutes for Mr. Peach to argue the rebuttal.
For rebuttal, okay. So it'll be 10 and 5. All right. Y'all, if you would just go ahead and introduce yourself to us too. Obviously the appellees, but.
Yes, Your Honor. Bryce McKenzie from the Superior County Bar, Foster from the Blount County Bar. We represent Mr. Garner, who's here with us today. In the audience, I'll be in the argument.
You will be doing that. Okay, that's fine. We'll hear from the appellant.
May it please the court, the trial court respectively erred when it concluded it had subject matter jurisdiction in this case, and as a result, the trial court's order is void and this matter should be reversed and remanded in favor of the appellants. As an additional matter, review of the trial court's order on subject matter jurisdiction is properly before this court despite the suggestion otherwise. Subject matter jurisdiction may be raised at any time in any court. That's Church of God versus Haley Ministries, and that includes a subject matter jurisdictional bar of ecclesiastical abstention doctrine. This court can also, subject matter jurisdiction may be raised by the parties or it may be raised by the court, sua sponte, and that's Nangdem versus Beavers, Court of Appeals case 2021. The Haley case set forth the rule that ecclesiastical abstention doctrine is a bar to subject matter jurisdiction. That doctrine precludes courts from adjudicating questions of faith, ecclesiastical rule, custom or law, or church polity or internal governance of a religious organization. In the context of a defamation claim, as we have here, courts must look to whether the statements were made during an ecclesiastical undertaking, and that's Osley versus Shaw, Court of Appeals 2005 case. So first, what are the communications at issue here? Those have been briefed and referenced in both parties' briefs, and there are two communications at issue. First is the letter from the Credentials Committee to Everett Hills Baptist Church in January of 2023. And then second is a follow-up conversation between Ms. Peters, the Credentials Committee liaison, and Pastor Douglas Hayes of Everett Hills Baptist Church, who received that letter. So what is the ecclesiastical undertaking? The ecclesiastical undertaking specifically is the Credentials Committee's inquiry into whether or not Everett Hills was in friendly cooperation with the Southern Baptist Convention. This letter is referenced and repeated verbatim in paragraph 19 of the amended complaint. That's the trial record volume 1 at page 21. And it's repeated in the response by the appellee on page 13. Credentials Committee's tasked with determining whether a church has a faith and practice which closely identifies with the SBC's adopted statement of faith, namely the Baptist Faith and Message of 2000, and to determine whether the church may be acting in a manner that is inconsistent with the SBC's beliefs regarding sexual abuse.
Let me ask you this, counsel. In this case, though, I understand your argument that the statements that were made that were allegedly defamatory were made in the context of determining whether they were in friendly cooperation. But really, the context is irrelevant for determining whether or not the statement was defamatory. I mean, for our purposes, we don't need to get into the issue of whether or not the church was in friendly cooperation. Like those factors under that, we don't care. For our purposes, it just matters, was a statement made and was it defamatory? The fact that it may have been in this context, why does that automatically make that fall under the ecclesiastical doctrine when we don't do any ecclesiastical analysis?
That's a good question, Your Honor, and respectfully, I think it's set forth in the cases that we've cited in our brief, specifically Mays versus Friendship, as well as the Watchtower case. Those cases talk about the process and whether or not the communications at issue were, quote, inextricably linked to the ecclesiastical undertaking. So while this court does not need to get into a decision of whether Everett Hills was in friendly cooperation with the Southern Baptist Church, the fact that those communications were inextricably linked in that process under those cases, Mays, Watchtower, and even the out-of-state case, Lubbock, in 2021 from the Texas Supreme Court, that is why the court should consider it here. Whether or not Mr. Garner engaged in the act that is alleged is not of importance. And importantly, the church was asked what was the hiring process at Everett Hills, whether they had a process of reporting abuse, and respectfully, that church did not have that process, and now they do. And that's because we engaged in this process of of inquiry.
Well, maybe if that was all that was asked, we probably wouldn't be here, but it went a little bit further than that.
Well, this was an anonymous complaint, and respectfully, the church in and of itself cannot just sit by and let these allegations not be addressed. And so they have to make...
Agreed, but could it not have said, hey, we've received an anonymous complaint, XYZ, instead of saying, are you aware that this person has been accused of XYZ?
Well,
It's the wording, obviously, that's problematic.
sure, to the appellees. The problem is the subject matter of this court entangling itself into these communications that are inextricably intertwined are problematic, and which is why this court does not have subject matter jurisdiction. The second issue on appeal is the Tennessee Participation Act. The court erroneously concluded that it did not apply in this case. The trial court compounded the error by applying the incorrect legal standard. And irrespective of what standard is applied, Mr. Garner cannot prove a prima facie case of each element of his claims. And then finally, there was no determination of the third step of the analysis, whether there was truth as an affirmative defense, which is what's required. I think this matter clearly is based on or related to an exercise of right of free speech or right association. We've already defined the speech at issue. There are 7 categories of information that are public concern, which include health, safety, and community and well-being. And respectfully, under the Doe versus Roe case, that's Court of Appeals 2021, there the court concluded that the filing of a Title IX complaint by private parties said sexual assault is clearly an issue related to health or safety. Both communications implicate the right of free speech and the right of association. With all due respect to Mr. Gardner, they did not address that in response brief, and respectfully, those issues have been waived. And so this court should hold that the TPPA applies in this case, and the trial court incorrectly ruled otherwise. Step 2 of the analysis, which is probably the most important step, the more meatier step of whether the Garner has proved he stated a prima facie case. The trial court applied the incorrect standard. Appellees acknowledge in response that the trial court applied the well-known standard from Rule 12.06. Even before the recent Supreme Court opinion in Charles versus McQueen and Reese versus Rock Creek, this court reversed the trial court's application of that 12.06 standard. The standard set forth in Charles McQueen as the same standard as a motion for summary judgment or a motion for directed verdict, whether a rational jury could find in favor on a party on that issue. And significantly, the trial court has to apply the applicable standard of proof. And this is specifically relevant with the false light claim. Actual malice must be proven by clear and convincing evidence, and the trial court did not consider that in its analysis. With respect to the claim for defamation, respectfully, none of these claims, these two statements at issue are actually statements. They're inquiries and not statements. That's Secured Financial Solutions versus Weiner, Court of Appeals 2010. An inquiry itself, however embarrassing or unpleasant, is not an accusation or statement. A question is not defamatory if it relates to a genuine effort to obtain information. And that's what we have here. There was information reported to the appellants. Appellants acted on that information, and there was no defamatory statement. Appellee cannot also meet the prima facie case for defamation because the contents of the letter were actually true, something that appellees admit. Finally, as to defamation by implication, I'd ask this court to look at Aegeus versus Zelnick, Court of Appeals case 2013. In that case, which was a summary judgment case, the same standard that needs to be applied here, that advertisement in the campaign involving then State Senator Diane Black was held not to be sufficient to state a claim for defamation by implication. As for false light, I'll briefly address those. The wrong standard of proof was used, and there wasn't a publicity element of the claim. The communications at issue were not public communications. And I see my time has ended. Thank you, Your Honor.
Your co-counsel has time for rebuttal. We'll hear from the appellee. Excuse me, the appellees.
Yes, Your Honor. Again, Bryce McKenzie of the Sevier County Bar. And I'll address the issues in the same way that they've been presented by the appellant, starting with the subject matter jurisdiction issue. And it's really been a theme in this litigation that the SBC and its affiliated entities have essentially argued that because they have a religious affiliation, they get almost a heightened sense of protection. Because when it comes to the ecclesiastical abstention doctrine, our Supreme Court's been very clear on when this doctrine applies. And if this court can weigh into a controversy based upon neutral principles without having to enmesh themselves in actual religious doctrine, this court has found that it can assert subject matter jurisdiction. So whereas the defendants, the appellants, are focusing so much on the actual undertaking of this letter being sent, really what we look to is what legal principles are needed. And our Supreme Court made that very clear in the Red Wing v. Diocese of Memphis case. In that case, the Catholic Church had asked the court not to exercise subject matter jurisdiction on an allegation of negligent hiring, firing, and supervision. And it argued that the ecclesiastical abstention doctrine should apply because that would be the court weighing itself into hiring practices that would be very literally within the church walls. And our Supreme Court, in a 2012 opinion, very wisely cautioned against that type of overbroad use of this doctrine, warning that religious institutions do exist in a broader secular community, and that this doctrine should not be implicated unless the actual conduct complained of is rooted in religious beliefs. So the purpose of this is not to place churches in an elevated status. As a matter of fact, to do so would be in violation of the Establishment Clause. The purpose of this doctrine is that this court won't interfere in actual religious doctrinal policy. But here we have a clear defamation claim that can be determined without accounting any religious principles. And in the Red Wing case, the church made the same argument they made here, that, well, our church practices oppose sexual misconduct. And the Supreme Court wisely found that that is too broad of a statement. We cannot just make these overarching moral and legal statements and try to say they're doctrinal in order to avoid this court's jurisdiction. So when we look at the subject matter jurisdiction on this case, We have made a defamation claim, and that defamation claim can be determined by the neutral principles. They are not embroiled or enmeshed in the doctrine of the SBC or its affiliated entities. So because of that, this court should exercise jurisdiction over this matter. Also, from a procedural perspective, we are in this court because of a basically special carve-out provision of Rule 3 that allows an instant appeal on a denial of a TPPA claim. I understand their argument that the subject matter jurisdiction can be determined by the court at any time. But part of the issue with that is there's two ways to determine subject matter jurisdiction, either facially, based upon the complaint alone, or factually. I'm unsure the record's clear on what exactly they're asserting, but to the extent that it's factual, there still is a record that could be developed in the lower court. I just want that to be something this court considers in making that determination. Moving on to the Tennessee Public Protection Act. This is an anti-SLAPP law, a relatively new one where the law is coming out from this court because we're just now getting to the point where cases are reaching the age to start developing this case law. But the important part is, what does SLAPP mean? Anti-SLAPP. It means strategic lawsuit against public participation. Right in the purpose of the law, right in the title of the law, is the legislative intent, which is to make it more difficult to sue somebody participating in some sort of public exchange. This controversy, in and of itself, is a private exchange. It was a letter from these defendants and their various entities to a church defaming Mr. Garner regarding
Counsel,
an allegation.
let me ask you too, at this point, go ahead and address what, as I understand, opposing counsel said that, look, these weren't statements, they were inquiries, and as inquiries seeking information, they simply couldn't be defamatory.
Absolutely, Your Honor. And I don't believe that that is the case at all, because if a question in and of itself implies a defamatory meaning, then it can still be found to be the basis of a defamation action. And the actual statement at issue is important. The letter stated in subsection 5, is the church aware of an allegation of sexual assault of a minor involving Preston Garner during the time he served at Englewood Baptist Church, Rocky Mount, North Carolina? That is not an open-ended question. That is a statement that clearly implies that the SBC and its affiliated entities have knowledge of a credible allegation of Mr. Garner committing some form of sexual abuse. And we know that that is the way that it was interpreted, because we know that Mr. Garner lost 2 jobs over this. That has been put in the record through the affidavits in our response to the TPPA. So the utilization of a question mark in and of itself is not enough to get them out of it being a defamatory statement, because it certainly weighs with it the implication of information that's not true. For example, the way that this statement actually reads is that the allegation of sexual assault occurred while Mr. Garner was serving at Englewood Baptist Church. In other words, that some concurrent, back in 2010, statement had been made, which is not the fact at all. The only thing about this anonymous, unverified allegation is that was called in sometime in 2022, some 12 years after the alleged misconduct, with no further research or investigation done to it whatsoever. So the utilization of a question mark and posing it as a question in and of itself does not save it from a defamatory meaning under the restatement of torts and under the defamation by implication, Your Honor. The church, again, the SBC, a state church. They are an affiliation of different religious entities that work with different churches. When they allege that the anti-SLAPP law should apply, it is almost an assumption that the First Amendment is implicated whenever a religious organization acts. It is almost the same type of argument they have made on the ecclesiastical abstention doctrine. But there's no showing that this was any sort of public dispute. There is no showing that this in and of itself was any form of right to speech or right to assembly. It's almost like the SBC defendants want us to assume this just based upon their position as a religious affiliated organization. But again, this is a very private matter, and this court just released a case last week. And in that case, there was an argument that McMurdy v. Safro is the name of the case. Mr. Costner with us was on that case, but on the different side in that one, considered whether a dispute, when there was a statement that was allegedly defamatory, and in that case the allegation had been that a security guard had said things that could be implied as being racist, whether it was a public dispute. And this court decided not.
Counsel would, obviously that case is not in your brief. If you would just send a letter to the court clerk with just the style of the case and say it's just no argument, just style of the case, and it was a case you referenced in oral argument.
Absolutely, Your Honor, and that came out on Thursday. And
I know, that's why it's not in there, yes.
But the reason that's important is because certainly we could argue any statements can be related to something that is a public concern. But the allegations that were made against Preston Garner were not about the overarching issues that the SBC had dealt with in their 2021 convention. This was about one specific private allegation. And the TPPA should not be considered so broadly as to include essentially anything that a church said that could be considered as part of a public concern, which is essentially what the SBC defendants are alleging in this. Moving lastly to the prima facie case, although the trial court did use the 12b-6 review on the facts, thankfully we did get from the Supreme Court a clarification. And there was another portion of the prima facie review that was important that was not mentioned in the opening presentation, and that's the courts to view this evidence in a light most favorable to the parties seeking to establish the prima facie case and disregarding countervailing evidence. And although that is a different standard than 12b-6, it is very substantially similar, and based upon that, we believe the trial court's ruling should be upheld. As far as whether or not this statement can be considered defamatory, Judge Sweeney, I believe that you would address that when you asked these questions. This obviously was something that was considered defamatory because we know the actions that were taken by the various entities that fired or did not extend employment offers to Mr. Garner. It was taken as a credible allegation of sexual abuse, a credible allegation that a not credible allegation as a result of the evidence that has been submitted via sworn declaration in Mr. Garner's response to the TPPA. The trial court also correctly found that these type of allegations and the statement in which it was made was substantially certain to become public. And again, the facts ferret that out. That is absolutely true, and we can see because it did get spread. It did go to other actors. It did get to the board. It did get to the King's Academy. So as a result thereof, a prima facie case for defamation, defamation by implication, and false light have all been met, even were this to court to find that the Tennessee Public Protection Act applied. The last thing that the SBC and affiliated defendants bring up is that the trial court erred by not specifically considering their defense. They allege that their defense is truth because indeed a allegation was called into a private line that was unverified, and they were merely repeating that. The court specifically found that that is not the case, that this letter implied a whole lot more than that. And I believe, Judge Davis, when you were asking questions to the appellants in this, you really nailed down that issue, because the context of the letter is important. They did not say, we've got this allegation that came from somebody anonymously that's not verified. What they said is, we're worried you're not in compliance with what we believe in SBC. We believe you're not doing the right thing. And in that same letter, they're saying, were you aware that Mr. Garner had been accused of this heinous and, as we allege, untrue thing? That certainly has defamatory meaning. It certainly can be taken as defamatory, and it certainly is not defendable as stating its truth, because the way that it was presented was in a way that is still defamatory. So the court specifically considered that. So regardless of whether he actually put the specific words in his order, it's specific on the record, and that record was included when he made his order. So as a result, Your Honor, we ask that the trial court be affirmed and that we be remanded back to continue to litigate this case.
Thank you. Hear from the appellate in rebuttal.
May it please the court, Matt Peach of the Nashville Bar. I represent the Southern Baptist Convention. And I want to respond primarily with 2 points. First, this is not the Red Wing case. The Red Wing case has to do with negligent hiring, retention, and supervision. It is not about communications. And that's incredibly important in the court's analysis of the facts of this case, because, as has been mentioned in the interchange with Judge Davis, the context is very important. It's true, as Your Honor mentioned, that the court in this case is not being asked to decide whether or not the Everett Hills Baptist Church is in friendly cooperation with the SBC. However, the letter that's at issue making that inquiry is unquestionably an ecclesiastical undertaking. And when it's an ecclesiastical undertaking, the court's analysis then turns, as the Osley versus Shaw case instructs, as to whether or not the communication is too close, and I'm quoting here, too close to the peculiarly religious aspects of the transaction to be segregated and treated separately as simple civil wrongs. In other words, given that the Credentials Committee letter making this inquiry of Everett Hills Baptist Church is an ecclesiastical undertaking, the question becomes, can the court then parse out language from that ecclesiastical undertaking and treat it as a separate civil wrong, or analyze it without getting too close to the tenets, the polity, the beliefs, the reasons for the letter being written in the first place?
Counsel, what makes that letter an ecclesiastical undertaking?
What makes the letter is because of as stated in the Southern Baptist Convention Constitution and bylaws, and what defines friendly cooperation, and whether or not a Southern Baptist affiliated church is in friendly cooperation specifically includes whether or not that organization, among other things, and all of those elements are listed in the briefs, but whether or not it shares the fundamental SBC tenets on faith and belief, and specifically in this case, beliefs regarding the issue of sexual abuse.
So if that were not specifically laid out in the SBC's doctrinal beliefs, then it would not be an ecclesiastical function.
I think it would be a different case. for this court to decide, because the reason for the letter is based upon why the Credentials Committee exists in the first place, which is pursuant to that bylaw and those bylaws and Constitution, and charge it with these purposes that are rooted in the tenets of the organization, of the religious organization. So I think that if it was just, I think Your Honor is correct that if those aspects of the purpose of the Credentials Committee were not rooted in the underlying organizational structure and reason for being of the Southern Baptist Convention as expressed through its Constitution and bylaws, I think it would be a different question for this court.
I'm just wondering, as a practical matter, like what church would not have, hey, we're against sexual abuse as a doctrinal belief, whether it's written in their doctrine or not? I mean, it would seem to me that really every organization that exists would be against sexual abuse. And the fact that whether it's stated or not as part of their doctrine, I'm not sure that becomes ecclesiastical.
Well, but I think that illustrates the argument as it relates to whether or not questioning whether or not it's rooted in religious belief, questioning whether or not it is too close to the peculiarly religious aspects of the underlying transaction, in this case, the inquiry. I think that's why it is precluded by the ecclesiastical abstention doctrine. I'm out of time. Thank you.
Thank you. Court's thanks to all counsel for your arguments today and your briefs on this. We will get you our opinion as soon as we can. Yes. Call the next case, please.